Good morning, everyone. Welcome to the Michigan Supreme Court September Administrative Public Hearing. We have 7 items on the agenda today for which we have speakers endorsed. I think about 12 speakers endorsed, and we will get to work. The first item, number 1, is a proposed amendment to Michigan Court Rule 1.109 that would address e-filing issues related to updating authorized user accounts and e-service of documents that are returned as undeliverable to a registered email address. We have 1 speaker endorsed, KimCramer from Michigan Legal Help. I should have said everybody has 3 minutes to speak. We might ask you questions and keep you longer, but the timer will indicate how much time you have left. Ms. Kramer, please proceed.
Thank you. Good morning, and thank you for the opportunity to participate in this hearing this morning. My name is KimCramer, and I'm here on behalf of the Michigan Legal Help Program. We provide a website with self-help resources to the many Michiganders who have to face legal problems without lawyers. I'm here to talk about the procedure for updating contact information in the e-filing system, because we think the rule as written has the potential to confuse and convolute the court process, particularly for users, for people without lawyers. We would first urge the court to eliminate any requirement of filing a form just to tell the court and other parties that information has changed in the e-filing system. This is the exact kind of information streamlining that technology can accomplish. And so we hope that the court will allow the technology to take the place of additional forms in this instance. We do realize that in circumstances where one party is e-filing and another is not, there will need to be a paper notification on the non-filing party to keep them informed. In most cases where e-filing is required, however, all parties will be e-filing. Since all service and notifications will be moving in and out of the e-filing system, the parties don't even really need to know one another's information or when it changes. We hope that the software vendor can ensure that whenever a user updates information in the e-filing platform, that it is electronically and seamlessly shared with the courts, who obviously do need to know this contact information. In the course of drafting our comment, we realized that there's not a process in the court rules generally for changing contact information. So we suggested language in our comment that would put a general rule in place with notice exceptions for cases in which all parties are e-filing. Even if this is impossible, there are some places where the rule is overly broad or we found to be unclear. If the rule is imposed on all litigants, it needs to be clear what a party will need to do to follow the rule. For example, the rule says that a user must file and serve written notification of, quote, any change to the user account. And we're certain that the court doesn't intend to require written notice of changes to things like updating your credit card expiration date or changing text message notification preferences. So we hope that if this rule is approved in anything like its current form, the court will specify what changes do require notice. Finally, some of the rules related to changing contact information are mixed within other sections of the court rules. One of the substantive additions currently sits in the definition section, while another is right in the middle of a set of pretty chronological rules of request an exemption from e-filing. Our comment offered suggested language to assist with this. Thank you for your time and the opportunity to comment. I'm happy to answer any questions you might have about our concerns. It looks like my internet might be popping in and out, so I could have been frozen. And so if I talked through any questions, I apologize. But things are moving now for me.
No problem. You did not, and thank you very much. Are there any questions for Ms. Kramer? Thank you for your comments. We appreciate it. My internet is also unstable, so we'll see how this goes. If I turn off my camera, that's why it sometimes stabilizes our screen a bit. Item number 2, we will move directly into. These are proposed amendments to Michigan Court Rule 6.302 and 6.610 that would eliminate the ability for a court to establish support for a finding that a defendant is guilty of an offense charge, as opposed to an offense for the defendant is pleading guilty to. We have 3 speakers on this. The first is Alecia Chandler from SADO. Jessica.
Good morning. Thank you. Jessica Zimbelman from the State Appellate Defender Office. I won't belabor too much what we wrote in our submitted comment to this court in July, but I did want to highlight for this court that our concerns with the changes to the rule are not based on any efficiency concerns, but rather equity concerns. And we have, of course, in our letter termed these pleas not as fictional pleas, but as equitable pleas. And that's what we really see for our clients, that in a system that can be very unfair, especially to certain people who are accused of crimes, poor people and people of color, that this ability to enter an equitable plea with in conjunction with the prosecutor's office is really a small fix to a system that can be stacked against a person, and a fix that really creates individualized sentences and solutions for people who are in the criminal legal system. And so while we understand this court's concerns on paper, whether there are questions of fairness or the appropriateness of allowing a person to plead to an offense charged rather than an offense committed, for the reasons outlined in our letter, the allowance of these pleas is really an equity issue for our clients, and we urge the court to reject these proposed changes to the court rule. And I'm happy to answer any questions about anything the court has or parts of our letter that we submitted to the court.
Thank you. Are there questions for Ms. Zimbelman?
Thank you.
Okay, Judge Travis Reeds. Thank you, Jessica. I don't see Judge Reeds in the Zoom room, so I'll move to Valerie Newman.
Thank you, Chief Justice. Justices, I am here to just acknowledge that the Access to Justice Policy Committee of the State Board submitted a very detailed letter to the court. I'm happy to answer any questions that the court has. I, like Jessica, will not belabor what we already submitted. I just want to add from my personal experience in my new role as a prosecutor, I find that pleas are a small form, or actually a large form, of justice that can be accomplished in the system every day. Almost 97% of all cases are resolved by pleas. It's an exceptionally important part of the criminal legal system. It's something that pretty much every single person that's weighed in, every committee of the state bar, the judges have been opposed to any change to this rule. I would just urge the court not to cabin judges' discretions at the trial court. We do have to trust everybody to play their role in the system, that everyone would do this according to their constitutional duties. And I think the more rigid we try to make the court rules, the more difficult it is to achieve justice in the courtroom. If there's any questions, I'm happy to answer them.
For Ms. Newman?
Yeah, this is Justice Viviano. I guess my question is, the legislature writes the laws and creates punishments for crimes in our state. But this practice allows us by private agreement to ignore those laws and those punishments and instead come up with one that the parties to a case and the judge thinks has a better punishment, even if the elements of the crime that's being pled to do not fit the defendant's conduct. Doesn't it trouble you that by a private agreement, we're allowing parties to avoid the legislature's punishment for crimes?
No. Well, when you phrase it that way, Justice Viviano, anyone not following the law certainly troubles me. I'd like to reframe the question a bit, if I could, to say it doesn't trouble me that people work coherently in the system to try and achieve, to do their best to achieve some measure of justice. And so I think the change in this court rule would not accomplish what it appears to be trying to accomplish, which is putting more rigidity into the process. If the court is finding cases or seeing cases where you see that as an issue, I would say on a case-by-case basis, that's something that the court can deal with when those cases come before it. But to make a wholesale change to try and rectify what might be an issue that crops up here or there just adds a rigidity into the system that's going to do a disservice to everybody. And as a former trial judge yourself, I know, I don't have to tell you that, as a trial judge, you want the flexibility when you're looking at a case to be able to, achieve justice in whatever manner is possible. And I was a defense attorney for 25 years. I viewed probably thousands of cases in my time at SADO, and I can't say that I ever saw a problem with so-called fictional pleas.
I think the issue is highlighted by Professor Johnson in her letter that she wrote us, and also the Innocence Clinic at Michigan. They submitted, I thought, a very thoughtful letter. And the problem is, I guess, if people think the law is unjust because it has a mandatory minimum sentence, or it has collateral consequences that people don't think match the crime, even though the legislature did because they put it in the law. Arguably, what should happen is the prosecutor should exercise his or her discretion to dismiss that charge, or people should petition the legislature to change that punishment. But as Professor Johnson points out, by allowing this sort of routing around the problem, we ensure that unjust laws remain unchanged. And also, we let prosecutors off the hook from having to make difficult decisions and exercise their discretion. And so we have to do this sort of privately in the back room of the court to achieve what they've referred to as rough justice, because nobody wants to do this out in the daylight and sort of acknowledge what's going on here. Isn't that sort of the core of the problem? We're perpetuating the system by doing what we're doing.
I don't think you want to get me off on this tangent. The system's inherently and systemically unfair. Prosecutors have enormous power and enormous discretion, and often don't use it wisely, but often they do. So, I mean, I think the basic issue here is making a rule change like this is going to make things, if you're trying to force things to be better, you're going to make things a whole lot worse for thousands of people who go through the system and enter a guilty plea. Although arguably I could argue against myself and say, I don't think this happens that much. So will it affect that many people? Probably not. But is this the way to effectuate systemic change by putting more rigidity into the court rules to try and force the round peg into the round hole? Of course, people can advocate for legislative change. People have advocated for changing the mandatory minimums on felony firearm for years. They've been unsuccessful. Even judges generally don't like those mandatory minimums, and many have testified against them, but they remain. We all know that there's multiple forces at work between the legislative branch, the executive branch, and the judicial branch. And changing a court rule in this manner is not going to effectuate. I guarantee very little in life, but I will guarantee you it will not effectuate change. Certainly not the change you're looking for. If we want to effectuate systemic change, we have to look at bigger, broader movements on how to do that. And I would argue that if a case comes before the court that looks like a fictional plea where you don't think the elements were met, then the easy way to do that is to withdraw, presumably the only way, the natural way it gets to you is with a defendant's motion to withdraw the plea, then allow the plea to be withdrawn with some language that indicates the prosecutor, that this is why you're doing it.
The concern is not the cases that get to us. The concern is whether this practice where people are punished for crimes they didn't commit, where the statutory punishment doesn't meet the conduct, and where the crime data is recorded as though someone committed a crime that they didn't commit and didn't commit the crime they did commit. So that's not accurate. And whether the defendant thereby is really acknowledging guilt for the conduct the defendant engaged in and accepting society's punishment for that crime, and all of that is a mismatch, right? All of that sort of goes by the wayside in these cases to achieve this sort of rough justice. So the question is, the system is supposed to have, I think, as its highest aim, truth, right? Seeking the truth. And in this particular dark corner of the system, we actually value darkness. Not, we don't bring light to what we're doing, and we don't, it's not transparent, and it doesn't. These pleas don't accurately reflect what has happened in a particular case. That's the problem. It's not an appeal problem. You're right. We rarely see these kinds of issues on appeal. The question is whether this is a good, healthy practice in our criminal justice system.
I think we have an imperfect system, and everyone in it is trying their best to, or the presumption is that everyone in it is doing their best to achieve some measure of justice. I mean, if I, as a prosecutor, charge a crime and I overcharge it, there's no reason to force a defendant into a plea, into that overcharging situation. I mean, it's from people who are, I know you've heard from a lot of people working within the criminal legal system, and there's pretty much universality of the people who are in the trenches doing the work opposed to this. And I understand that on the theoretical end, there's some people who think that, if we don't allow this, we can force change. But that's not the practicality on the ground. And the practicality on the ground is everyone's doing their best to work within the parameters that the system has set out to achieve some measure of justice. And that forcing these rules, I'm sorry.
So I was just going to say, I appreciate the exchange we've had, and I don't want to monopolize the time today. And I also feel a little bit bad because when Ms. Zimbelman was speaking, I wasn't quite warmed up yet and ready to ask a question. So I don't know if she wants to weigh in with any brief comment on what this conversation, but I thought I'd at least give you an opportunity to, since you've so patiently stayed with us today.
Well, I appreciate that. And I think Val covered it well as one of my former mentors. She kind of hit the nail on the head, but I do want to point out that, and we talked about this in our letter a little bit, that the plea bargaining system as a whole, to a certain extent, allows for the avoidance, if you will, of the prescribed punishments by the legislature through diversionary programs or reduced charges or any of the various things that can happen through a plea bargain. So I did just kind of want to point that out, that this equitable pleas, or as the court calls them, fictional pleas, aren't the sole issue with the plea bargaining system. I would just add that to what Val so aptly covered.
All right, thank you.
And I see Judge Reed's, is now here. So Justice Viviano, you might have one more set of answers to listen to, and maybe some more questions. Judge Reed's.
Thank you very much, and I apologize to all of you for being late. I'm bouncing my Zoom docket, and we had a little bit of technical issues, but and I wanted to make sure I took a break to represent the District Judges Association on this issue, and briefly on the issue of the Judicial Council, if I may. I apologize that I missed this. I think I missed some important things here. The request was to address the issues of effectiveness and propriety. From the district judge's perspective, I'm going to push back and indicate that I think that this moniker of a fictional plea is not suited to this discussion of changes to 6.610, particularly with regard to the district court, and 6.302 in the felony realm. And I vehemently disagree with Ms. Johnson's premise that truth is a bargaining chip. Plea bargains, while they may be negotiated behind the scenes, are placed on the record in open court. In other words, there's no deception, there's no lying that goes on. And I understand that she's a very bright lady and she's a professor at Rutgers and so on, but, and I just read another article she posted this June. The implication is that all of the stakeholders are engaged in bargaining away the truth. And I truly push back on that. We don't bargain away the truth as judges, certainly not in Michigan. It's on the record, it's a negotiated thing. It's not just a means to expediency. It's not a means to avoid trials. We have a duty to make sure that there is some articulable basis before we accept the plea. Her premise is faulty in many ways. In other words, almost all criminal scenarios provide for the truthful application of multiple different crimes or charges, not just one. There's not always just one crime that might fit any given set of factual scenario that might come up And when a prosecutor exercises that discretion to initially charge and then continues that executive role to negotiate thereafter, for the myriad reasons that we all know from practice, it might be a proof problem. It might be a factor in mitigation. By way of example, let's take a retail fraud case. A person who steals an apple at Walmart that's worth 10 cents versus a person who steals a set of headphones that's worth $199.99. Both have committed the crime if they have larcenous intent of retail fraud in the third degree. The statute gives us the parameters that we have to execute our job as judges, but those people have both committed the exact same crime. Is a plea bargain in the case with the apple justified? Is it justified in the case of the headphones? There are so many factors that could apply. The statute can't provide for all of those. Let's just use the numerical amount. For every penny worth of difference in value that's stolen, we can't have 20,000 different versions of what the punishment could be or what the just result could be. So I think it's a mistake to look at this in terms of what is the fair result versus what is the label that's attached at the end of a negotiated plea bargain. Both sides have the ability to say yes or no at that point, and it doesn't mean that the articulated factual basis is untrue. The record that's made before the judge is still something where the defendant is articulating facts in support of self-conviction. And let's also remember, I think it's important to remember, that the defendant is the person of everyone involved in the system who probably has the best relation to what's the truth. Even if we have a trial, which is really more of a test of proof as opposed to a search for the truth, even a trial is not going to get you as close to the truth in many cases as what the defendant themselves actually knows to be the truth, one way or the other, guilty or not guilty. So when the defendant articulates that, when they accept that plea bargain and they self-convict, that mechanism, I think, shouldn't be looked at as patently or systemically untrue. That's part of and so the effectiveness of the system can't be understated. It resolves cases because they should be resolved, whether it's a resource allocation or such the case of the apple and the headphones. In other words, sometimes the facts and mitigation absolutely justify the prosecutor negotiating to a different label. Sentencing goals like rehabilitation and crime deterrence, we respectfully submit that those are not positively impacted by a change like this. Very rarely does the label have an effect on deterrence, certainly in the district court. For the district court perspective, sentencing guidelines, habitual offender status, parole eligibility don't apply, but restitution would. Restitution would be impacted, given current precedent on that. It's the conviction offense, which is key. But again, the prosecutors has the ethical duty to keep that in mind when they're negotiating. Collateral consequences clearly are affected if this rule were changed. Collateral consequences of a reduced or alternate plea, very clear. Frankly, that's why a lot of defendants accept plea bargains, is because of considerations like that. But again, as long as they have honestly articulated a factual basis that supports either the charged offense, which sometimes is easier for them to do, or an alternate but yet true factual scenario for the plea bargain offense, it's still not a deception. So this idea that this is a systemic deception, we don't agree with that. And changing this rule doesn't have the impact, as some of the other speakers have said, of actually changing whether or not the laws and punishments that the legislature have given to us to work within are fair or not. That's a completely different issue. And I agree in many of the ways with that, but that's not my job as a lowly district court judge or any of us as district court judges to decide whether the law is right or not. We just have to follow it. And so I think changing this rule would push perhaps that in a way that is not appropriate. And we would ask you very respectfully not to change this rule. It won't have the desired effect, nor is there really a problem here because everything is done on the record. There is no deception, certainly not any intentional deception.
Thank you. Thank you, Judge Reeds. Let me see if there are questions for you from anybody. Okay, thank you all for your comments. Appreciate it. The next item we have speakers on is item number 5, and this concerns amendments and additions to the State Bar of Michigan rules regarding attorneys' succession planning. The first speaker is Kimberly Uhuru from the Attorney Grievance Commission.
Good morning, and thank you, Chief Justice and Justices of the Court. I'm here today on behalf of the Attorney Grievance Commission to support the proposed amendments to the current receivership rule. If adopted, these amendments would expand and improve upon the receivership program currently run by the Attorney Grievance Commission and transfer that function to the State Bar of Michigan. The need for this rule is neither abstract nor theoretical. Our current roster of 44,000 licensed Michigan attorneys, approximately 14,000 of those are over the age of 60. And as this demographic of the bar continues to age, there is a very real threat posed to the interests of clients from lack of succession planning by private law firms, and especially those run by sole practitioners. So this is an issue that directly affects a meaningful percentage of the bar. Today, I would like to specifically address two issues highlighted in the staff comment that was published by the court. The first is the issue regarding tolling under Section C of the proposed rule. Under that proposed provision, there would be an automatic 90-day tolling period of certain court deadlines, because many case deadlines, such as filing or briefing deadlines, are already set by court rule or by internal scheduling orders of a court. These kinds of deadlines could and should be extended by the rule amendment. We realize the statutes of limitation are a bit different because they are created by the legislature and are usually told by provisions within the statute itself or by common law. But we request that if the court determines that the tolling of statutes of limitation is outside the scope of authority of a court rule, that the court redact just the language regarding statutes of limitation, but adopt the remainder of the tolling provisions for the purpose of protecting client interests. The second issue I'd like to address is under Section F, which gives circuit court judges jurisdiction over files and records of an affected attorney. This portion of the rule could be narrowly interpreted to give judges jurisdiction over the custody of physical files, or in the case of electronic files, access to those files, solely for the purposes of transferring them to an interim administrator for inventorying. The rule need not be broadly interpreted to give the appointing court jurisdiction over, for example, the substantive legal issues in the affected attorney's files or records. And such a limitation could be expressly stated in a comment published with the rule. We support these amendments because the current AGC program, simply put, cannot serve the needs of all who come to us. We believe that these amendments will allow greater protection of the public, and we urge the court to adopt the amendments as written or with the minor revisions suggested in this comment. And I thank the court and would welcome any questions that you have.
Are there any questions for Ms. Uhuru?
I have a quick question. Ms. Uhuru, one thing I'm wondering is, does it make sense to just do a baby step where the bar, you have to, when you renew your dues, provide who your backup attorney is? I know I've had all variations of law practices, small, large firm, solo. So I am acutely aware of this issue. I know a lot of insurance companies, malpractice carriers actually now require this as part of your renewal, that you provide information regarding who has the keys to the kingdom, so to speak. So I'm just wondering, does it make sense to do a baby step first, the way the bar currently is doing? And I'm wondering what's sort of the impetus to create this, this new program.
Right. So the first part of that question, well, let me address the issue of the malpractice requirement. I don't think that's going to get us where we need to go. For one reason, just because we don't have mandatory malpractice rules in Michigan. So many attorneys, just do not have malpractice insurance. So the fact that insurance carriers are requiring that is not going to affect them. Whether or not we should take a baby step, I do know that the bar has for the past 2 years put a voluntary question on the bar due statement asking attorneys whether or not they have succession planning. And I think the information I saw in the bar records was that about 65% of attorneys report that they do have some succession planning. However, 25% report that they do not, and 11% just did not answer the question. So that is concerning to me, because that is a significant portion of the bar that either is not doing that or is not answering that question. I do think there is a need for an expanded program. I can just tell you from my experience in handling, receiverships as a staff attorney for the Grievance Commission for years, and now as the deputy, screening those requests and assigning them to staff attorneys. We do get requests that we cannot fulfill just because there are not the resources. Our current budget allocated for receivership is about $5,000 a year. And I can tell you on the receivership that we just opened this summer, the shipping cost just to get the 100 bankers boxes to our office was about $2,000. So you can see how the allocated funds get exhausted pretty quickly. And this is a program that requires, a dedicated paralegal, attorney supervision, filing costs, storage fees, things like that. So there is a need for a more robust program because there are cases where, people come to us and we just can't take the matter because we don't have the resources. I do think that we need to look at a more planned effort as opposed to just doing this catch and catch can. And I think that this rule provides for a more robust and planned response to this problem, which I do think is going to be a growing problem because we have an aging bar, frankly.
Thank you.
Thank you very much, Ms. Uhuru. The next speaker is James Harrington. You are muted, Mr. Harrington.
Unmute. Can you hear me now?
We can. Perfect.
Thank you. I've been in practice 48 years, former chair of the section, family law, member of the American Academy of Matrimonial Lawyers, but I speak only for myself. But after 48 years, I think I fall in the group of concern here because these issues are on my mind. In my motions, I like to tell the judge what relief I'm asking for and then talk about why. What I think should happen here, because it's critical that we obtain buy-in and support from the bar as a whole, particularly private practitioners. The Supreme Court could certainly sign off on this today and we will have to deal with it. But I think buy-in and support from the practitioners, because we're talking about a huge increase in dues here, is important, and that there's a lot of issues that I think should be explored in an open format. For example, the costs are estimated at $250,000 to $350,000. Is that the real cost today? That was the cost in the report 2 years ago. Is that a realistic cost? And are there any caps? What system is there to review the costs of the program? I would also comment that I think the terminology is unfortunate, because affected attorney in the era of COVID sounds like an infected attorney. And I think we can accomplish the same thing by referring to a private practice attorney and then the list of the 6 circumstances under which that person would fall within the program. I think we also should have some clarification on how does this impact retired attorneys? The proposed court rule refers to resigned attorneys, but where do retired attorneys fit within this? Are they within this program or not? There is a new standard, I believe. I haven't done malpractice lately, but there's a good faith standard imposed here, which I don't know that there's a body of law on good faith regarding administration of a program like this in order to confer immunity. And I'm thinking that perhaps it should be cast in terms of traditional standards of negligence, gross negligence, or how exactly is the standard to be determined here if there's a claim against an administrator. I also thought when I reviewed this, and I only saw this last week, my fault, not yours, but I only saw it last week, that the limitation to private practice attorneys only and putting the sole financial burden on them is a slippery slope. It obviously, we all have issues and we all have concerns about affected attorneys, if you will. But focusing the funding only on those attorneys rather than all members of the state bar, I think is potentially problematic. And it certainly would be interesting to know, and that's why I requested extension of the comment period for additional information. What do we anticipate the cost will be as just private practice attorneys? And what do we anticipate the cost will be if it's the state bar as a whole? I think that's important information for you to consider. There's no limitation on the annual fee. And the informal feedback I received is Well, how much is this going to cost down the road? Well, no one knows. We do know what the database of costs so far are, but I haven't seen that in the proposal.
Mr. Harrington, let me interrupt you and see if we have questions for you. You're
Thank you.
3 minutes. Let me see who has questions for you. Seeing none, I'm going to move to Alecia Chandler. Thank you, Mr. Harrington. Ms. Chandler.
Good morning, Chief Justice and Justices of the Supreme Court. My name is Alecia Chandler, and I am Director of Professional Responsibility Programs for the State Bar of Michigan. First, I want to thank Justice Kavanaugh and Ms. Boomer for taking the time to discuss with us some of the concepts and concerns that the court had problems with in the initial draft of the proposed interim administrator program. I hope that we have satisfactorily responded to many of your concerns in the supplemental memorandum. And I understand that some of the concerns that were just outlined by Mr. Harrington were addressed in that memorandum as well. And I wanted to say that the State Bar agrees with Deputy Administrator Uhuru and the comments that she provided. And we want to ensure the court that the interim administrator program will still be highly effective if we don't have, for example, the tolling program or some of the other concerns or the terminology that Mr. Harrington is concerned about. We're not wedded to that terminology. Really what it's about is the underlying protections that this program provides to the bar and everyone involved in matters being handled when an attorney becomes unexpectedly unable to practice law. Because it helps to ensure that all attorneys have an effective succession plan in place. So we talked about baby steps a little bit earlier. So we can talk about the Ohio experience where on their registration the first year, a number of people did have to nominate other attorneys and one nominated Mickey Mouse. So we want to make sure that the program that we have in place has checks and balances. So a mandatory succession planning, ensuring that the attorneys are meeting their ethical obligations. And I would encourage the court, if you'd like a description of what those ethical obligations are and how that fits into the rules of professional conduct, you can review Ethics Opinion RI 374. That talks about 1.2, 1.4, all of those ethical obligations. So that's number one, making sure they meet those ethical obligations to protect clients in the practice of law. There will be no increase in dues to lawyers who choose to nominate an interim administrator on their own. The only way that there would be an increase in dues is if they chose to participate in the bar-sponsored program. The budgeting process for the State Bar is very open. We post those on our website. The court has an opportunity to review. So those increased costs, the concerns, those are real concerns of practitioners, but they have been addressed and they are also addressed in the supplemental memo that you have been provided. This program reduces stress for the attorneys, families, clients, and we believe that it is the best program to effectuate a solution to a huge problem.
Thank you, Ms. Chandler. Are there any questions for Ms. Chandler? Thank you all for your comments. We appreciate it. Very helpful. The next item concerns a series of rules regarding the appointing authority, the funding unit's appointing authority to appoint counsel for indigent defendants in a criminal proceeding. We have one speaker endorsed, Nicole Smithson, from the Michigan Indigent Defense Commission. Ms. Smithson, wow, that's a mouthful.
Good morning, Your Honor. Thank you. My name is Nicole Smithson. I'm a regional manager with the MIDC, and I was also on the team that submitted the amendments to the court rules. Our agency previously submitted written comment, so I'd like to focus my remarks on MCR 2.117 and then address any questions that the court may have. Some written comments that were previously submitted concerning 2.117 B3B object to this provision. And this provision basically would allow an appointing authority's notice of appointment to act as an attorney's appearance. or to function as an attorney's appearance. Allowing a notice of appointment to act as an appearance was intended to do two things. First, reduce the delay between the appointing authority making the assignment and the court learning of the assignment. And number two, promote clarity by allowing courts to rely on that notice of appointment the same way that they were relying on orders of appointment. It's important to note that the proposed amendment does not require local funding units to file notices of appointment. Instead, the proposed amendment gives local funding units the option to do what they feel is best for their jurisdiction. That concludes my remarks. Are there any questions that I can address?
Thank you very much. Are there questions for Ms. Smithson?
Well, thank you for considering our amendments.
Thank you very much. The next item is number 9, a proposed administrative order that would make it mandatory for all courts to submit case information to the Judicial Data Warehouse in a uniform manner. The first speaker is Alecia Tripp from Michigan Legal Help. Ms. Tripp.
Morning, Chief and Justices. Thanks for allowing me to speak on this. I'm Alecia Tripp, the Director of the Michigan Legal Help Program and Vice Chair of Michigan's Justice for All Commission. I'm here today to talk about the impact of this proposed order on access to justice issues in general. During the pandemic, Michigan Legal Help noted a dramatic increase in the number of people accessing our personal protection order materials and forms. I mentioned this to an SCAO data analyst who showed me data that PPO filings were actually down over the same period, in stark contrast to the previous ways that Michigan Legal Help and SCA and filing data trended together. This discrepancy sparked many conversations and actions that increased people's ability to file PPO petitions, which was a struggle during the pandemic because clerks' offices were closed or limiting access. We even worked with several court clerks' offices to enable email filing of PPOs right from Michigan Legal Help. Without Michigan Legal Help and SCAO having and sharing this data, this access barrier for a very vulnerable population would not have been known about or addressed, and courts wouldn't have been convinced of the need for email filing. We were able to do this with the current incomplete and inconsistent court data that exists now, but imagine what other important problems are missed and what innovative solutions could be implemented if we had complete, consistent, and valid court data. As another example, many partners, legal aid, the Housing Assessment Resource Agencies, and MSHDA really need to know complete and detailed data on how many eviction writs are being issued right now since the eviction moratorium is no longer in place. This would help with short and long-term financial resource planning, determining representation priorities, and homeless avoidance measures. But the court data that we have right now on these numbers is of poor quality because of what SCAO has access to is incomplete, inconsistent, and not always valid. This proposed order is the first step towards resolving these issues and making higher quality court data available to SCAO, the public, and to those who will use the data to improve the public's ability to handle and resolve their legal problems. Access to quality data is incredibly important, not just to data enthusiasts like me. So many access to justice principles and projects look to data to identify places where people struggle to access the system, to look for solutions, and to measure efficacy of solutions. Data-driven decision-making is fundamental to increasing access to justice. The Pew Charitable Trust is helping the Michigan's Justice for All Commission in its data analysis, and also submitted a comment on this proposed order, highlighting things like the importance of court data as a way to show transparency and how accurate and complete data is required for effective case management, as well as to evaluate innovations and take advantage of funding, research, and technical assistance opportunities. Additionally, this court data is critical to many other justice system partners as well, like Michigan Legal Help, so we can effectively and efficiently deliver the legal advice, representation, information, and collateral services needed by so many people. I recognize that there are concerns around ownership of data and privacy, and these have been well voiced in other comments on this proposed order. These comments should not stand in the way of enacting this order, but be seen as an indicator of the work still to be done beyond this order. I hope that the SCAO and this court will pull together a team, including external impacted groups like the JFA's Technology and Data Sharing Committee, to work through these important questions because it's critical to resolve them quickly so this project can move forward full steam ahead. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Tripp. Are there any questions for Ms. Tripp? Okay, next speaker is Kevin Bowling on this same topic. Mr. Bowling, go ahead.
Good morning. Thank you, Chief Justice and Justices. I'm Kevin Bowling. I'm Court Administrator for the 20th Circuit and Ottawa County Probate Courts. Thank you for your leadership in advancing the value of the Judicial Data Warehouse. The stated goals of this proposed administrative order, including improving access to court records and promoting transparency, are of critical importance to the effective administration of justice. Our courts support these goals, but respectfully submit the administrative order is overly broad as proposed. Specifically, the order states, quote, trial courts must submit all case data, including non-public and financial records, to the Judicial Data Warehouse in a format and frequency defined by the SCAO, close quote. The reference to all case data is troubling because it immediately establishes several conflict situations. For instance, recent legislation made all juvenile court records non-public. So if a trial court submits case data to the JDW, we will be violating statutes to comply with the order. If trial courts submit tax returns that are part of friend of the court files, we'll violate IRS regulations and jeopardize our Title 4D funding. If trial courts submit PPO case files, we may release confidential address information and put victims of domestic violence at risk. If trial courts submit all civil files, we will inevitably release personal identifying information that will lead to identity theft. Perhaps it would be more responsible to consider what data is necessary to achieve the goals of the order. Then define the data elements and train court staff so data is entered properly to ensure high quality data. Only data that will be used for an identified and valuable purpose should be submitted. This will make better use of limited public resources and ultimately increase public trust and confidence rather than damage it through unintentional injury to litigants whose confidential information becomes public. A helpful revision is to remove the word all and leave discretion for local judges who are best positioned to determine what data is likely to cause significant injury. Submitting aggregate data to show the workload of the courts without exposing personal information is also an option. However, the proposed language requiring the submission of all case data does not allow for that option. Trial courts are also concerned about the broad discretion of the SCAO in determining the quote format and frequency, close quote, of data to be submitted. For courts that are currently on JIS, this could be accomplished by simply scraping data with no input at all from the trial courts. For trial courts with other case management systems, there'll be reprogramming costs, which may be an unfunded mandate and cause undue burden to the trial court's funding unit. At minimum, you would lessen concerns by convening a representative group of court managers to assist with determining the appropriate format and frequency of data submissions and provide some financial hold harmless language. Thank you for the opportunity to share these comments, and Ottawa County stands prepared to assist with improving this proposal to ensure data quality, accountability, and transparency. Thank you.
Thank you, Mr. Bowling. Are there questions for Mr. Bowling? Thank you both. That concludes today's hearing. Judge Reeds is not able to return to speak on item number 10, the Michigan Judicial Council, but asked us to pass along that the district judges are in support of the Judicial Council. Thank you to all of our speakers, and that concludes today's hearing.